Hello, everyone, and good afternoon. I'm Maureen Olhausen, former acting chairman and commissioner at the Federal Trade Commission, and currently the co-chair of the competition group at Baker Botts. And there goes my name tag. But anyway, it's my pleasure to introduce the next panel, which is on competition and intellectual property, how to create a diverse innovation ecosystem. And I think some of the discussions we've already heard today underscore the importance of how these two topics interact. So we all know innovation isn't easy, and it's a very long and winding road from idea to invention to development and to commercialization. And each of these steps can be risky and expensive and unpredictable. And strong intellectual property rights promote a vibrant economy by encouraging innovation. And empirical research supports the fundamental role that patent rights play in promoting innovation, and I've written at length about the positive correlation between IP, robust IP rights, and R&D investment. Now, a diverse ecosystem needs players who specialize in different parts of that innovation chain, from R&D to patenting to licensing and implementation. And though IP licensing is generally pro-competitive, antitrust enforcers do have an important role to play in protecting against competitive abuses. But the role of antitrust should not be to dilute IP rights. And doing so inappropriately morphs antitrust law into a tool for price regulation and creates harmful disincentives for innovation. So in recent comments to the Department of Justice Antitrust Division, Jim Rill, the former head of the Antitrust Division, and I discussed the need to promote open standardization and robust competition on the merits at the time of standard setting. And the FTC and the DOJ have explained many times the benefits to consumers of open standardization and competition when technologies vie for inclusion in a standard. But this competitive system only works if patent holders are assured that the valuable technologies that they contribute to a standard will not be undervalued due to the bargaining frictions unique to SEPs. So discussions about standard setting must take into account the consumer welfare effects of eroding incentives for SEP holders, as well as the consumer welfare effects of chilling implementers from practicing the standard. And if SEPs become devalued, powerful companies will have the incentive to go it alone and create walled gardens with closed standards. And this, kind of getting back to the topic of the panel, this would undermine diversity in the ecosystem, which is otherwise fostered by giving small businesses an opportunity to compete in a market with an open standard. So it's my pleasure to introduce the next panel. It will be moderated by the Honorable Deanna Oken, the managing partner of Aducci, Mastriani, and Schaumburg, and the former chair and commissioner of the United States International Trade Commission. And she will be joined by the panelist, Professor Jonathan Barnett of the Gould School of Law at the University of Southern California, Jorge Padilla, a senior managing director and head of Compass Lexicon, Bob Taylor, founder of RPT Legal Strategies, and Edward Lazarus, the chief legal officer at Sonos. So please join me in welcoming the panel. I'll let you all come up.
Well, thank you, Maureen, for that introduction and for those remarks, and certainly continues in what we have heard today, this thoughtful discussion on important topics on competition, on intellectual property, on the US role in the world, what China means for us. I mean, so many topics have been hit on, and I have the distinct honor today of moderating this panel of experts, and we're going to continue the conversation, this time focusing on diversity, in the IP system and what that means. And it means a lot of different things. And we bring the panelists bring a number of perspectives to that topic. So without further ado, we're going to start with Jonathan. And then each panelist is going to say a few things, and then we'll engage in a dialogue and also hope to have some questions from the audience. Thank you. Go ahead, Jonathan.
All right. Thank you. And I'd like to thank LeadershIP IP for the opportunity to speak to you today. One of the previous panelists had mentioned that the culmination of a scientist's career can often be a product or service that can actually impact people's lives and improve human well-being. I think for a legal academic or a social science researcher, what they really ultimately want to achieve is to leverage their research into policy changes that can improve society. And so what I'm going to try to do in the next 5 minutes is to consolidate about 10 years of research into 6 slides. And through those 6 slides, I'm going to seek to establish 3 propositions. One, I'm going to try and show you, and this will be the easy part, that big tech really doesn't like patents. Second, I'm going to try to show you why they don't like patents, and then I'm going to put those 2 points together to try and show you that the policy place that we've got into in the patent system is conducive to one particular business model for monetizing innovation, but it's not good for most others. It leads to a transactionally impoverished innovation ecosystem. And just one terminological note, by big tech, I mean a much broader set of companies than what we might associate with that term today. I mean any company that monetizes innovation through a complex system of products and services. All right, so I like to make all policy arguments based on fact and evidence because far too many policy arguments in this space have been made on rhetoric and slogans. And so what I did to figure out what companies actually think about patents is to see what they say in the amicus briefs that they filed with the US Supreme Court. I collected all amicus briefs that were filed in a 10-year period in cases having to do with patents. And there's a pretty surprising finding, which is that business in general doesn't really like patentees. Only about 30% of the time they favor patentees. Why is that surprising? Well, I thought patents were a monopoly right. So wouldn't you, if you already have an entrenched market position, wouldn't you want a legal entitlement that makes it even stronger? Well, that suggests, as I'll get into, that perhaps patents are not best characterized as a monopoly right. The other finding is that as firms get larger in size, they like patents even less. Only about 20% of the time do Fortune 500 firms favor the patentee. Private firms, who tend to be smaller, are more even-handed in favoring the patentee or the infringer. Then look at academic institutions, which are obviously exclusively focused on innovation. They have no production or forward integration capacities. Almost every patent case that they see, they're going to favor the patentee. We can take this data and we break it up into different industries. And the key finding is that there's basically 2 camps out there. Our systems-based industries, which is ICT, financial services, automotive, are especially systems-based industries like ICT platforms. They're usually favoring the infringer. Whereas in the other camp, VC, and of course the startups that they're backing, academic institutions, biopharma, big and small, they're always with the patentee. Now, why is that the case? Well, systems-based firms are taking an innovation, either ones that they originated or those that they imitated, and they embed it inside a complex system of products and services, or they embed it in a vertically integrated production and distribution infrastructure. It's really hard to replicate that. You could replicate one component, but you can't easily replicate the whole system. And so they can easily monetize innovation without heavy reliance on the patent system. Not only that, in a system that has weak patents, they have a competitive advantage over who? Over the companies that are in the second camp, who are standalone innovators. They require the patent in order to enter into licensing or partnership relationships with others. So what this predicts is, if you weaken the patent system, are you going to destroy innovation? You might in biopharma. Outside, innovation is going to continue, but it's going to continue only in a certain type of business model, in an integrated business model. Just one more data point. Big tech was one of the largest or most prominent advocates behind the America Invents Act. One of the centerpiece features is the Patent Trial and Appeals Board. That was in the act that they advocated for. and they are far and away the biggest customer. And it might be interesting to know that the majority of the companies that are targeted with petitions challenging patent validity in the PTAB are operational companies. It is also interesting to know that in excess of 15% of the petitions that are filed at the PTAB are filed in the biomed sector, and there has never been an assertion of significant unconstructive NPE activity in that area. All right. Now we got to the second question, and the second question is whether or not the weak patent ecosystem, which suits a systems-based model of innovation, that's good for the companies that advocated it, otherwise they wouldn't have advocated for it, but is it good for the innovation economy as a whole? We actually don't need to totally guess on this, because we've already watched this movie before. In a forgotten and surprisingly long period of US patent history, running from roughly the late 1930s through the 1970s, patents were very difficult to enforce. And the market, of course, responded, where you see the per capita patenting rates are historically low throughout this period. It's not an attractive way to monetize innovation. With the establishment of the Federal Circuit, the per capita patenting rates leaped up. Did our innovation system collapse as a result of excessive transaction costs and litigation costs because the courts started issuing injunctions, they started issuing meaningful damages awards? Not at all. What happened is that within a decade of the establishment of the Federal Circuit in 1982, there was a quadrupling of the share of R&D dollars spent by private business that are attributed to small firms, less than 1,000 employees. Is this a fluke? Is it surprising? No, it is entirely expected, because with a patent in their hands, the small firm innovator can level the playing field against existing incumbents that can outperform them on every single other component of the supply chain. It allows them to enter into fair and arm's length negotiations, whether it's a license or a partnership with firms that are much larger in size. Did innovation collapse during what I call the patent winter, during the post-World War II period? No, it did not. But it almost only took place at places like GE, Bell Labs, DuPont, RCA. A robust innovation economy is business model agnostic. The central planner has no idea what is the correct business model for any particular technology at any particular time. But the market will discover it through competitive forces. Just as competitive forces discover efficient pricing, they discover the efficient way to organize the innovation process. The key social cost to weakening the patent system is our innovation economy becomes distorted, and it is only conducive to firms that are larger and that are systems-based, and that is fundamentally at odds with the key purpose of the patent system, which is not only to incentivize innovation, but it's to incentivize entrepreneurial innovation. Thank you.
Thank you so much, Jonathan. I really appreciate you setting up the panel with a fact-based presentation, and I think it's a theme we're going to return to. And with that, I'm going to turn to Bob Taylor, and I know that he will probably pick up on this theme of Jonathan's of the historical, looking at history teaches us something about what we should be thinking about going forward.
I will, thank you. First of all, I'm very pleased to be here and very happy to see that the turnout and the diversity of points of view that are in the room. And it's a real pleasure to be back in 3D people instead of 2D people. My own practice has been, I've been trying patent cases for about 40 years, and I came back to the patent world after some time spent as an antitrust lawyer. When I got out of law school in 1969, the professors that I had for patent law told me that I shouldn't consider patent law as a career because the courts were not enforcing patents and it was kind of a moribund profession. And I took that advice and I went to a firm that had 3 cases in the Supreme Court that were antitrust cases, and spent about 10 years doing that. But then the patent system came back to life, and I've done a lot of that as primary practice for all that time. In the last 10 years, I started working with venture capital firms, which is why what Jonathan just was talking about is to me so important. Judge Michelle mentioned this morning, and Steve Sissolka mentioned it as well, that one of the primary purposes of a patent system is not just to incentivize inventors, but to incentivize investors. And that means incentivizing the entrepreneurs who want to start companies. People look at the protectability of taking on long-term risk if they don't sense that there's strong patent protection at the end of the tunnel, they simply take their money elsewhere. I work with an organization called Alliance of U.S. Startups and Inventors for Jobs, a mouthful, but it's USIJ is the acronym. And we took a lot of NVC, National Venture Capital Association data a couple of years ago and started looking closely at the data because we were running into an argument trying to promote a stronger patent system that it really wasn't necessary because venture capital was alive and well, and you could see the growth in venture capital like between 2004 and 2017. There was a fourfold increase in venture capital, and that was the period of time during which the Supreme Court was in one decision after another, making it harder and harder to enforce patents. When we took a close look, though, by segment, what we saw was something quite different. We saw that venture capital money was not flowing to the patent-intensive industries. It wasn't flowing to the strategic industries that are really critical to the United States security and health and well-being. They were flowing to the marketing companies and the hotels and restaurant chains, and the shift was really dramatic. And so we commissioned a professor at the University of Akron to conduct a study. You've probably run into it, perhaps. And that's it's called it's a study of venture capital in that time period and where it went. Professor Schultz did his own analysis of the NVCA data, but he also did a lot of analysis of the patent office data, and he interviewed inventors and venture capitalists and produced a very interesting and compelling report. What it shows in a nutshell is the shift of venture capital away from the patent-intensive industries into these less important, not unimportant to the investors, but less important to the overall health and well-being of the United States ecosystem. It's important to think about this as we go through the panels today, because it is why we have a patent system. And for those that have paid close attention, you see that the patent system has been gradually eroded to the point that today, in my personal opinion, the relevance of patents to small companies that are about to start any kind of a technology company, where they're going to have to go head-to-head with one of the entrenched incumbents, not just in the tech industry, although it's probably more pronounced there, but the automobile industry and a lot of other industries, you're just not seeing venture capital come along to support that.
Thank you, Bob, and that's actually a good segue, Eddie, to hear from you. Eddie at Sonos, in your role, you've certainly been both a company that is battling the entrenched tech industry in terms of bringing your innovation, the company bringing its innovations to market. So I'd love to hear your perspective on how the IP system can better incentivize that type of activity.
First of all, thank you so much for inviting me to be on this panel. It's my first time here, and I have to confess that I am not an IP expert, but I do live every day on the front lines of what Jonathan and Rob have outlined here. Sonos, for those who don't know, is a real American tech success story. It was started by four guys in an apartment in Santa Barbara, and it's now close to a $2 billion revenue company that's profitable. What they did is they saw a problem, a consumer problem that they wanted to solve. And the problem that they wanted to solve was home audio. And the fact that if back in those days, if you had a stereo system, the only way to make it play was to have it all connected by wires. What the founders of Sonos invented is wireless multi-room home audio. And that was a steep technical challenge, how to connect these speakers wirelessly over Wi-Fi to make them synchronize properly so that the music sounds right. How do you set it up? How do you control it? How do you synchronize it? And all the technical problems of the next generations as streaming music came online. We're the biggest open platform for streaming music. Over 100 different music services are available, and you can play different music in different rooms at different volumes and all kinds of things like that. It was a wonderful business and grew nicely in the early years. Then it turns out that the smart speakers, which is what Sonos devised, it turns out when you put a microphone in it, it's actually a gateway into the smart home and a collector of vast troves of personal data. And you can imagine how interested big tech became when that became evident. And so along the way, some of the largest companies in the world started producing what are in essence copycat products that infringe on the many, many patents that Sonos gathered along the way. We have more than 1,000 domestic patents now and 2,000 worldwide, and moved into the space. They built these products, they cross-subsidized them from their very profitable other businesses, sell them at or below cost, and flood the market. So that's the dilemma I faced when I got to Sonos a little over 3 years ago. What do you do about that problem? We're not talking about a small amount of infringement. We're not talking about 1 patent or 5 patents or 12 patents or 50 patents. We're talking about, in our estimation, Google infringes on over 150 Sonos patents. Of course, you want to try and reach a licensing arrangement. But let's assume, as the case is here, that after some years you figure out you're never going to get there. What do you do? And that's when you have to stare the problems that we're talking about at this conference in the face, because you can go to federal court, but as Judge O'Malley pointed out in the last panel, what do you get at the end of the road? What you're likely to get is the royalty agreement you should have gotten up front. And yet it takes years of litigation to get there and many millions of dollars and a distraction. You know, we're a company that wants to think about the next innovation. We don't want to be thinking about the past. You can go to the ITC and try and get injunctive relief there. But it's a very particular kind of injunctive relief. It's an importation ban. Recently, the ITC has opened things up so that if the defendant in the investigation can produce redesigns. But the redesign system is kind of stacked against the plaintiff because you don't get to, let's say you have 5 patents in the case, as we did at the ITC. The redesigns, either by ripping features out or working around them, they can get around the importation ban. But the plaintiff never gets to show, oh, but these redesigns actually infringe a whole bunch of our other patents. So you end up in a game of whack-a-mole. I'm very pleased to say that Sonos won we sued on 5 patents. The ITC has held that all 5 were both valid and infringed by Google. At the end of the day, we're going to do okay. But the problem of whether you call it piratical infringement or essential or efficient infringement in the federal court system is very difficult to confront. And the injunctive relief available at the ITC is sometimes less complete than it ought to be. And that just, for a company like Sonos, we have the three things you need to be able to confront big tech. We have a terrific patent portfolio that we have tremendous confidence in. We're a mature enough company that we have the resources to fight this fight for however long it takes, and we have great lawyers. But if you're missing any of those ingredients, you just can't sustain it. And for companies that are smaller, the kind of companies that venture capitalists are looking at or that Jonathan's talking about, that's just an impossible challenge. And so the worry is that no matter how smart you are about patenting your inventions, that if you're at those early stages, you really can't defend yourself from the infringement. And so we're very pleased to be on the front line. We're going to carry this battle through to the end, but it's a difficult one, and it does illustrate the shortcomings of the system that we have today.
Yeah, Eddie, that's such an important perspective from a company out there on the front lines battling, kind of what helps, what doesn't, and what are the obstacles, and hopefully in our Q&A we'll have a chance to talk about things like the draft policy statement, which would actually undermine the ITC in terms of even its ability to offer an exclusion order for standard essential patents, which I know is not your issue, but we'll come back to that. But before we do, I'd love to hear from Jorge, who I think has thought a lot about what diversity in the IP space means, and will help us think about that as we continue our dialogue.
Thank you very much, and thank you for the invitation. Before I take you to diversity, I would like to take you away from the real world for a second to go to the realm of ideology and economics. And when one thinks about what is why antitrust policy evolves in a particular way, why antitrust ideology evolves in a particular way, one key driver is the evolution of economic ideology. And therefore, you have to look at what economists have been writing about to understand why is it that we have the antitrust policy that we have these days on both sides of the Atlantic? And if you look at the economics literature about innovation and IPRs, with some exceptions that are sitting back there, most of the literature has contemplated a model, a situation, a simplification of reality that to some extent and avoidably leads to the conclusion that IPR is bad for innovation. Because in those models, IPR is about monopoly, is about the right to exclude. In those models, therefore, IPRs are inversely related to competition. They're bad for competition. In those models, competition is essential for innovation. If you don't have challenges, there is no innovation. Ergo, IPR is bad for innovation. In those models, patents are granted almost randomly, and oftentimes as a result to people that don't deserve that protection. In those models, in addition, there are very few incentives on the part of implementers to challenge patents. So lots of patents are bad and survive. Hence, those models talk about efficient infringement. They don't talk about holdup. And they tell you that anything that enhances the bargaining power of the IP holders is bad. Hence, those models predict that injunction is bad. Now, those models are models. Models are not representation of reality as scale 1-to-1. I mean, it would be absurd to have a map of the world at scale 1-to-1. By selecting the features that you introduce in those models, you, in a sense, influence and direct the conclusions. And once those models are produced once and again over 40 years, especially over the last 20 years, then not surprisingly, you have an entire generation of economists, of policymakers that think that those are self-evident truths. And that's the situation in which we are. And that's why it was not difficult to predict, using an unsophisticated econometric model, that a Lina Khan would emerge, or that Tim Wu would emerge, or that Andrea Coscelli in England would emerge, or that you would have Margaret Vestager. It was to some extent obvious. It's the result of a literature that has generated an ideology that has been largely unchallenged. Now, what you're not going to find in the economic literature, although I'm pretty sure that all of you think that we should have, is the idea that in the marketplace of innovation, there are diverse business models, that some people are vertically integrated, that others are pure innovators, that some vertically integrated or pure innovators license and others don't and try to protect their competitive advantages through trade secrets. In those models, you're not going to find that some people have the incentive to hold out, because not only that provides them with a competitive advantage in the markets where they work as implementers, but also may disadvantage competitors on the innovation game, because deprives resources, limits the cash flows of those people, especially small and medium enterprises that need those cash flows, because this is the fundamental blood for their opportunities. Because those models don't exist, because people have not researched along those areas. You have policymakers that ignore those facts and ignore those realities. Believe me, it is important to have experience of the real world, but it's important to transform those experiences into narratives that get exposed once and again, because they influence ideology and they influence policy. If you talk to most antitrust officials on both sides of the Atlantic about diversity in IP, they would think, what are they talking about? Is this about race, ethnic diversity? What kind of diversity you're talking about? It's not about diversity in business models. If you tell them that innovation is actually a random process, not only probabilistic in the sense that you may be successful or not, but probabilistic in the sense that the ideas may arrive to you or to you or to you, and we don't know ex ante who's going to receive those ideas. They wouldn't understand what you're talking about. They don't realize that the intellectual coefficient is the only thing that is well distributed in the world, and that therefore you want to make sure that whoever gets an idea is able to develop it and make a living out of that. Because that's the value of diversity. Now I think that we have been talking a lot of negative things about China. Let me just make a positive quotation about this time about Mao when he said, "Let 1,000 flowers bloom." That's the idea of innovation, that it may arrive to one or another entity, and we need to have a system that allows people with ideas to make money out of them. And the IP system is not about the right to exclude, or not, most prominently in my opinion, is about the right to license, the right to monetize. How can you understand standard setting, which is based on the idea of cooperation, without understanding that people to cooperate need to have well-defined rights? That's the only way in which you can have give and take, and therefore benefit from that cooperation. So, my message today is that if we want to promote diversity, we need facts, we need real experiences, but we also need narratives that are repeated once and again, so that, believe me, may not be tomorrow, may not be the day after, but at some time in the near future, we can offset the existing bias and move the pendulum in the right direction again.
Thank you, Jorge. And I want to pick up on a number of threads, some that were common among you and some that were different. And I want to go back to this venture capital study. Bob, you mentioned, I think, Jonathan, I know we had a discussion when we were putting this panel together. What worries you about the venture capital study, and what would you say would be the policy prescriptives that would help incentivize the inventor, incentivize the investor, help monetize, as Jorge has just said, and the licensing? What are your prescriptions?
I'm not sure what the right answer is, except that the one thing that I know is that 20 years ago, when I first started working with venture capital firms, they were doing a lot of IP due diligence with respect to new investments. Many of the investments that they were contemplating, they would examine the patents owned by that company. They would examine the patents owned by potential competitors and the incumbents, and see if there was a space in there to create a company that could actually survive and make money. And little by little, that interest in IP just disappeared from the general investments that VCs were making. The pharmaceutical area is the one exception, and they were doing it then, and they're still spending a fair amount of money doing IP due diligence before jumping into a new pharmaceutical product. But with respect to tech and optics and software, just not being done. I think the only answer is to make it more profitable. You know, venture capital flows to where they perceive the best returns are going to be, and when the best returns for your investors' money will come from investing in low-risk, short-term inventions or short-term companies. That's where the money will go. And for the money to get back into the high-risk, long developmental period technologies, those are just going to have to be seen by VCs as more profitable than some of the other sources they have to use with their money. One of the things that we've also seen over that 20-year period is that 20 years ago, 95% of all venture capital money spent in the U.S. Raised by U.S. investors were spent in the U.S. And at the present time, it's about 50%. A lot of that money went to China. Some of it went to Europe. Some of it went to South America and Mexico. But the bulk of it went to China.
And over what period was that again, that
changed? For about 20 years between, say, 2004 to 18 years, 2004 to the present.
Jonathan, I know you've thought about this in the venture capital, and you focus on facts and information. What do you learn from that study, and what does it tell you about what policymakers should be thinking about if we want to incentivize investors and inventors?
Sure. Yeah, I think that study is very important because it illustrates why transactional diversity is important and why it's important to allow the market to freely construct the fullest possible or select from the fullest possible range of transactional forms. Because you might think, well, that's just kind of an aesthetic choice. But it actually has direct efficiency implications, because what that study is telling you is by creating a patent system that is only conducive to certain types of innovation, you start to distort the allocation of capital to different types of innovation projects. And in particular, what you see in that study is you see a diversion of capital away from things like IT hardware, things like pharmaceuticals that might possibly have greater social value than an additional app for the Google Play Store. That also illustrates quite nicely another function of the patent system. This is why I don't like to call a patent a monopoly. A patent is a property right, because just like property rights in tangible goods, it allows a market to form, allows the market to price out the asset, and then the central planner doesn't have to pick where I should put my money. The market's going to direct it to the place where that capital can be allocated most efficiently. And so that study is very valuable. You asked me solutions. I always have I have just one item on my wish list, which is just legislative intervention to reverse eBay. Once you have the injunctions in place, you've got a property system again, and then the market can do everything else.
I think we'll agree with you on that. Eddie, I mean, your company sits, I guess, in the Internet of Things, something we're all talking about, connected devices. How do you think about the investment side from a business perspective? What do we need to do better?
So this isn't entirely a patent point. It's more competition more generally. But I think the question that the country faces and Congress faces in thinking about the antitrust legislation that is before it, and also definitely connected to patent protection, is whether we are going to reduce down to a very few operating systems within the smart home, just as we've reduced down to just 2 operating systems in mobile. I think most people would agree that having just 2 mobile operating systems is not good for innovation. And the same will be true in the smart home. If the gatekeepers are Amazon and Google, and maybe Apple sneaks in there a little bit, and maybe Facebook a little bit. If you're just talking about a handful of companies, things will not flourish. Whereas if you have if you have a lot more interoperability and better standard setting by neutral bodies, you will see a flourishing of the Internet of Things inside the home, because people will be motivated by different things. It won't be just about e-commerce, or it won't just be about search. It'll be about other things. And that will allow for a flourishing of innovation. We're not headed down that path today. So that's what we see, and that's what our concerns are. And I certainly share Jonathan's view that the injunctions is crucially important. Measures of damages is crucially important to try and foster greater protection for the fledgling companies.
Yeah. Jorge, I wanted to return to you and pick up on this theme of standard setting organizations and standards themselves, because one of the things, again, thinking about 5G being that the 5G is the backbone to the Internet of Things, and that standard setting is so important to 5G. We see this draft policy statement from the Department of Justice, which would essentially treat standard essential patents differently, right? Both the ITC and in the courts. It would remove the threat of injunction in most instances. How do you think about that when you're talking about what the important part of the system is? Again, thinking about the licensing and monetization. How do you have that dialogue that overcomes some of the what's said in this policy statement, that they seem a problem that they seem to be trying to address that I'm not sure exists?
Right. I think that the statement is focused, like many other statements in other jurisdictions, on the risk of holdup. And I think that two observations there. One, as you know, there is not that much evidence in favor of that, that there is a concern about holdup. But to the extent that that holdup could be a problem, it may relate to a particular business model. It's about perhaps vertically integrated companies that want to use their IP to foreclose others from competing with them in downstream markets. It's a concern that doesn't play or shouldn't play a role, at least as a matter of economics, with respect to companies that are pure innovators, because pure innovators only make money if they license and if people sell. So they're not going to want to kill the goose that gives or lays the golden eggs. At the same time, there is a parallel to this excessive emphasis on holdout. There is very limited emphasis on holdout. Holdout is treated as a mere distributional problem, something that at most concerns the transfer of rents between implementers and innovators, but it has no real impact on society, on the economy, on growth, on development. And that's fundamentally wrong for a number of reasons. First, because, again, for the reasons that I stated before, lots of companies require cash flows to continue innovating. Small, medium enterprises, startups require those cash flows. They don't have the luxury to wait until a tribunal one day will pay damages. That's not the way it works. And therefore, the holdout strategies are likely to undermine the investment prospects of those companies with real effects on the economy. But in addition, holdout strategies, which can be afforded by some companies but not by others, distort the level playing field in implementer markets. Some companies pay, some companies don't pay. Those companies that don't pay tend to be those that have big budgets and can litigate in multiple jurisdictions and ad nauseam. And that generates antitrust problems because it distorts competition. I think that the statement misses these points, fails to understand that holdup has real implications, both in terms of underinvestment and also distortions of competition. That is not a mere distributional problem, but a problem that has antitrust dimensions. This time, this holdout has antitrust dimensions and also creates problems in the markets for technology.
Yeah. No, Jonathan, did you have anything to add on the policy statement or on standard setting organizations and the role generally?
Sure. I actually think the issue with the SCP policy statements and similar statements made by other regulators in the past is actually a perfect illustration of the point that Jorge was making in his original remarks, which is that the regulatory consensus, worldwide consensus, with the exception of the antitrust division under the leadership of Makan Delrahim, has adhered to a simplified model of what happens in the market. It uses a model of a one-period payoff maximization model. I am a patentee monopolist. I have invented one standard, and I will never invent another standard again. So of course, I'm going to set the royalty rate as high as it will go, and I will leave as much for the implement, as little as possible, just so they could stay in business. Of course, we don't see that. We see that the royalty rates are very modest, and they're consistently modest over time. Well, if we had a normatively objective inquiry into how these markets work, we would go back and we would redo the model. And what the model should look like is a repeat play payoff maximization model where I'm maximizing my payoffs over time. So if I cheat you once, you're not going to license me again. And that explains why these repeat play reputation effects can account for modest, consistently modest royalty rates over time. And what it tells us is that holdup is a theoretical possibility that is unlikely to be realized. And when we looked at data relating to almost 3 decades of market performance, it tells us that this risk has not yet been realized. And as a policy matter, it tells us that if you have scarce enforcement resources, it is very curious that you would spend such a large portion of taxpayer dollars on this problem, which doesn't seem to be a problem.
Eddie, I was curious from, again, your business perspective, the role of treating standard essential patents differently, and the kind of your view of kind of holdout versus holdup, and what you see in the actual practice.
Yeah, we the standard essential patent problem isn't ours, and so I can't pretend to have studied it closely. But I have to say that the discussion of the models and the theoretical incentives involved ring very true to me. It just feels like exactly what we see in the world that we observe, even if we aren't particularly players in that world.
Yeah, because what reminded me of it in your comments was talking about being technology neutral, and it is one of the things. I'll talk about the ITC for a minute here in terms of the draft policy statements and the changes it would make to the ITC's analysis. And it's one of the things that I think is a strength of the ITC is that it's technology neutral, it's patent neutral. You look at the patent, you find out the violation or whatever the unfair act is, and then you have a remedy. At the end of the day, you evaluate public interest, and then there's still another lever. The president could have a policy reason for overturning an exclusion order, which the law allows because it's a trade agreement. But I think if you change that analysis and put standard essential patents in a different, like the Section 337 statute doesn't tell you to do that, right? It doesn't say you got to treat these differently. So I don't think it's consistent at all with the authorizing statute. But I think it's a more fundamental problem that you're putting them in a different category, a different bucket with a different remedy, when what flows from them is a number of the points that you touched on. And Bob, you want to jump in there, please do.
Well, yeah, I wrote a comment when the Department of Justice requested comments to this draft policy statement. I wrote one, which I think is about one of 1,000 that they got. They really got an earful from industry across the country, and I had 3 essential points. First of all, it's really improper to have a policy that comes out of the bureaucrats in the White House and not the agencies. 2 of the 3 agencies still don't have confirmed directors. And so where is that policy coming from? I don't think Jonathan Cantor thought it up on his own. So let's wait until we've got real directors in place in the agencies before we have any kind of a statement. Second, what do we need a policy statement for in the first place? It's not controlling on anything. It's simply a piece of paper that says this is the view of some people at one point in time in the United States government somewhere, and you shouldn't issue injunctions when standard essential patents are involved. And then the third thing is, though, this policy statement goes on to tell the parties how to negotiate. the implementer has to make this kind of a statement, and the negotiator or the innovator has to make this kind of a statement. What kind of government policy is that? I'm
We ask you.
baffled by it.
I agree. I agree with associate myself with all those remarks. And I know we have a lot of other content we can talk about, but I also am interested if we have questions in the audience. So let me take some of those. Start over here.
Hi, Bill Richterman in Covington. Great panel, fantastic, so interesting. If you had 3 wishes of ways to improve the patent system, 3 discrete wishes, so it can't be something big like fix it, what would those wishes be in descending order?
All right, I don't know who wants to start, although I know we've heard overturn eBay, so we've got at least one from Jonathan. Who else wants to jump in with their top 1 or 2 or 3? Yeah. Bob, please do.
I would start with overturning eBay, just like Jonathan. But KSR would be my next shot. And KSR, for those that don't know the case by name, the Supreme Court removed any standards for determining what is obvious in light of the prior art. And it allowed district judges and PTAB judges just to run absolutely wild with imagining all the things that should be in the prior art that really, realistically, you know or not. A friend of mine recently had a case in front of the PTAB, and someone dredged up an obscure reference in Chinese that wasn't even available in the U.S. library, and that became one of the pieces of prior art that the PTAB used to kill this patent. Now, no realistic inventor would go looking for that kind of stuff before trying to figure out how to solve a problem. That's my second one. And the third one is I think the PTAB, although well-intentioned when it started, has proved to be really detrimental to the invention community. We really don't need IPRs. It might have been okay if we had IPRs conducted according to the way they were originally planned and sold to Congress, and that's where there's going to be a proceeding very much like the European opposition proceeding. That's the post-grant review, the PGR, and then there's a secondary window that they talked about, which was the inter partes review, and once the act was implemented, that inter partes review just overwhelmed the rest of the system, including the patent office. So
Yeah.
those are my 3.
Jack, I like it. Jorge, you have 3 on there?
I'll just have one,
All right.
which is, so everybody, especially those that are in antitrust agencies, go back to year 2000. You have forgotten everything that you thought that you had learned about SEPs, and now what you have to learn is this fundamental lesson. Licensors have less bargaining power when the patents at issue are standard essential patents than when they are not standard essential patents.
I think if I were to pick
go
up
ahead,
on something Bob said, I'm more ambivalent about the IPR process. I think there are pros and cons to it from my practical experience. But one thing that I always get nervous about as someone who is a litigant is when they spin the wheel in district court and you find out who the judge is. I like development that I've seen in some parts of the country where judges volunteer to take on patent cases. They're very complicated, technically difficult cases in many circumstances. And to have self-selected judges who really want to get into the weeds on this, who like this kind of case, getting the bulk of the cases, I think would be a real plus for the system, because I think sometimes the delay that occurs is because maybe in certain circumstances, judges are like, oh my gosh, I just don't want to get into that. It gets relegated to some clerk who doesn't. I mean, I think you're just really better off if there's a self-selection of the judges at the district court level who take on these cases.
Well, we need Judge O'Malley up here to comment on some of that. I know you have views on that, but we'll save that for the cocktail hour. Jonathan, did you start to jump in with another?
I'm going to stick with reversing.
You're going to stick with reversing, all right. I like it. Thanks for the question, Bill. Others out there have a question for our group? While people are thinking about, someone tell me if the hand goes up. But I do want to, and I know maybe we talked about China a lot in other panels, but I do want to talk about it with respect, in particular, the standard setting organizations and how China views the standard setting organizations and how some of the things we're talking about impacts whether the US can have continued leadership in the standard setting organizations if the incentives change. Versus China's system of command and control in thinking about this. So anyone want to talk about China in particular in standard setting organizations?
So I would like to make the following observation. It's not so much about their conduct within standard setting organizations, but it's about what I think is at risk. And I believe that what is at risk is fragmentation of standards at a global level. And that I think that that's bad. And I think that we need to try to prevent that from happening. It may happen, but I don't think that is to the advantage of anyone. I'm not sure exactly how we prevent that from happening, but I think that that's a very serious risk. Because one of the things that has worked well with 2G, 3G, 4G, 5G is that we have global standards. That innovators have, therefore, the ability to monetize their innovations all across the world. Fragmentation of standards is going to be bad. We have historical experience of that, and we know that it is detrimental for everyone. And I have that serious concern that the attitude of the Chinese government and the Chinese companies may end up leading to that fragmentation, which, as I said, is to the disadvantage of all of us.
Yeah, please.
Yeah, so if I can add to that, I'd like to take your question and then just push it up to just one more level of abstraction. And I think the fundamental point here, which captures regulatory actions taken by Chinese competition authorities, certain decisions by Chinese courts. However, it is also equally true of the current draft SAP policy statement, of the SAP policy statement 2 administrations ago, of SAP policy statements taken in the EU. What do all these things have in common? They have in common that they are distorting the rules of the game. They are distorting the property rights system in order to transfer wealth from net IP generators to net IP users. Okay? The largest technology companies, whether you look at them in China or in the US, they are very valuable. I actually want to really clarify that. The platform companies play very valuable, essential parts in the innovation ecosystem. However, they tend to be aggregators. They are integrators of technology that are coming from the apex of the technology supply chain. We want our property rights system to be business model agnostic, to be technology agnostic, and to be agnostic with respect to any position you are in the supply chain. And what I think has happened in the SEP policy space, which is also true of the degradation of the injunction remedy throughout the patent system, is a distortion of the property rights to move wealth away from companies that specialize in innovation to companies that specialize in integrating innovation. We need both of those companies in the ecosystem, but there is no plausible public policy reason that I can fathom why you would favor one group over the other.
Yeah, that's a really important point. And one thing is, as we think about how do you talk about these issues in a way that makes sense to people, right? Because I think one of the things, and I know many have spoken about this, is if you don't see the technology and it gets aggravated onto something on your phone, let's just talk about your phone. You know, we know that the backbone of the phone is, you know, what makes it run. It was the cellular, it's all these things, but a consumer doesn't see that. They see their phone and they don't and I don't think they're thinking about it. I wonder if the pandemic gives any lessons that we take from that, because I think one of the great stories, and I know they were running on lots of podcasts, was just talking about, you know, who actually invented the vaccines, like the small companies. I mean, they end up getting distributed by the larger companies. But are there lessons from what we saw coming out, you know, vaccines being brought out at record speed, the antiviral drugs that were developed I know that's more in the pharma space, but are there lessons that one should take from that and amplify as we talk about these issues going forward? I don't know who wants to talk about that, Bob. Yeah.
One of the arguments that we often hear particularly from the large tech companies, is that well, little companies may have been good at one time, but that was then and this is now. And we are big enough to take on worldwide competition and make it work. And we're big enough to have R&D departments that can really develop all of the newest technologies. And I love to point out to people that I can give a long laundry list of companies that brought innovative new technologies, important new technologies into the marketplace. Qualcomm having been one, where the entire establishment said it won't work, you'll never make it work, and then after they made it work, we don't want it. But the COVID story is really good. It was two companies, and I mentioned, someone else mentioned earlier today that both Moderna and BioNTech had worked on using mRNA as a basis for a vaccine for a long time. Companies like Merck that specialize, among other things, in vaccines was not interested. And today, I heard the CEO of the German subsidiary of Merck on a YouTube video a couple of days ago saying how great the industry had performed without reference to the fact that these are two startups funded on venture capital that brought mRNA vaccines into COVID.
Yeah, no, it is a great story, and there needs to be more said about that. A question in the back.
Good afternoon. So we talk about the importance of having incentives for companies to invest in R&D and contribute their technologies to industry standards. What happens if we get the policies wrong? If these companies lose their incentives to invest in R&D and we lose this open standardization system, who will set the standards then?
Who would like to jump in on that one?
So the first thing I would like to say is what is the implication of eliminating incentives? And I'm going to tell you briefly a Spanish joke that says, this is a guy that says, I love playing poker and losing. So what about winning? Winning must be fantastic. What are your incentives to play poker if you lose all the time? Okay, it's pretty obvious. You don't need to have a PhD in economics to understand the lesson. If you don't have innovators, then you wouldn't have a problem, Oscar, because I think that you wouldn't have standards in the first place.
Eddie, you want to jump in?
Well, maybe I'll switch modern topics from COVID to the situation in Ukraine. The world is likely to disaggregate. We talked about that in terms of the fragmentation of standards, which I think is more likely than not at this point. So then the national security question in a way becomes, is the United States better off with a handful of companies doing all the innovation or with thousands of companies doing it? And it's self-evident. And so you have to provide the right incentives to make sure that happens. Because as fantastic, and they are fantastic companies, even the ones who I like to bash in the press. They're amazing companies, but they're not at the forefront of innovation in most of the fields that they operate in. That is, as Jonathan pointed out, the purview of others. And if we don't have that flourishing, other parts of the world will, because they have larger markets, for one thing, and they can operate on an internal market system in a way better than we can.
Jonathan?
Yeah, well, there's basically three ways that we see the world setting standards. Either the government can set a standard, we can have a single monopolist standard, like MS Windows at one point was, or we can have the market structure that we have in the wireless market, which is a market structure that is attractive both from an innovation perspective, we see continuous rates of innovation, and is attractive from a competition policy perspective because we have standard setting that is disaggregated, is not in the control of any one particular producer. Now, what is likely to happen if you pull patent rights out of that system, the capital has to migrate over to an alternative business structure that allows them to capture a positive return on their investment. And the next best way to do that is to move over to the MS Windows model, where you have one single company controlling the standard and extracting all of the rents. This is a very interesting illustration, actually, of, again, why it is inappropriate generally to call an IP or a patent right a monopoly, which suggests that there is an inherent tension between competition law or antitrust law on the one hand and IP law on the other hand. What you actually see in the wireless market is that these go hand in hand together. Where you have strong patent rights, you incentivize participation in a disaggregated standard setting process. You pull out the patent because you think it's making the market uncompetitive. Actually, you're going to make the market monopolistic if you do that. So I think that's what's likely to happen.
Rob, did you have anything you wanted to add?
The use of the term monopoly for patents has always sort of irritated me, partly because I guess I spent so many years as an antitrust lawyer. Patents are monopolies only in a very, very few instances. The pharmaceutical industry has a few places where there's no real therapeutic substitute. And in those cases, it's legitimate to talk about a short-term monopoly and all of the benefits that flow from that. But in almost all the rest of the world, a patent doesn't provide anyone with a monopoly because there are substitute ways of doing almost everything that you see patented. And so the term is really a misnomer, albeit one that the Supreme Court has used over and over again. They love it.
Well, and I think others have repeated this earlier, which is the trade-off is you give your patent to the world, and then you have this should be a virtuous circle of people designing around or finding better ways. And it's that second part that sometimes it seems gets lost in the policy prescriptions that we see coming out of Washington sometimes. Any other questions? Yes, right in the middle.
Jonathan talked about hold-ups, but with a lot of vertical integration happening, a lot of the major tech companies are becoming holdouts, right? So how to address that when you're looking at there's a lot of verticalization happening, especially in the, if you look at wireless and smartphone space?
Reverse eBay. No, it's as simple as that, because if you restore the property right, then you compel the parties to negotiate. You're actually going to reduce litigation, and you're going to preserve this very efficient equilibrium. What happens is when you pull the property right out of the system through all of these regulatory statements that are treating SCPs differently from other IP rights, coupled with the overarching effect of eBay, is that, as Eddie eloquently described, you're in a world of might makes right. The party that has endless litigation resources has no incentive to settle. Their rational business strategy is to litigate. It's not malicious. It's perfectly rational, and it's probably legally obligated in order to maximize shareholder value.
Yes.
You were looking at creative solutions to where we are. What do you think about changing the rules about willful infringement? So that, for example, that it would be 10 times the damages for willful infringement, or lowering the bar as a solution for these issues?
Eddie?
I think you already know what my answer to that question is.
Bob, did you want to comment? You spent a lot of time on this types of cases.
I wrote an amicus brief in the centripetal network system versus Cisco. And there, the judge found that Cisco had willfully infringed 4 of the 5 asserted patents and increased the damage award up to about $2 billion. And that case is now in the Federal Circuit. Unfortunately, the Federal Circuit has taken up the issue of whether the judge should recuse himself because his wife owned some Cisco stock, and Cisco raised that as a reason to disqualify him. not clear to me why owning Cisco stock would possibly prejudice the judge against Cisco, but it did, and so the Federal Circuit has taken that issue up, and presumably if they disqualify Judge Morgan, they will send the case back to the district court, and it'll get some other judge to go through the same rigmarole. But it's a compelling set of facts if you read the judge's findings of fact and conclusions of law.
Well, thank you. With that, I see we've run out of time for this panel, but I hope you will join me in thanking a panel who's brought both models, facts, history, business.